Thank you. Please be seated. Before we begin the calendar today, I'd just like to say it's truly an honor to be here at the Robert H. Jackson Center, holding a term of this court for the first time outside of an official court building or a law school. As most of you know, Justice Jackson was a true American patriot, serving his country not only as an associate judge on the N.Y.S. Supreme Court, but as chief prosecutor at the International Military Tribunal at Nuremberg post-World War II, in which his commitment to fairness and the rule of law helped keep order at an otherwise very chaotic time. It's our, and I'll speak for all of my colleagues here on the bench, it's our pleasure and our honor to be holding a session of this court at a center dedicated to such a man, and we deeply appreciate the overwhelming hospitality and warmth shown to us by the directors and staff of the Robert H. Jackson Center. They have really outdone themselves. And now, to honor Justice Jackson's commitment to the rule of law, we will move on to our calendar of cases.
Good morning. May it please the court. Lyle Hajdu for Defendant Arroyo. He's challenging the trial court's decision regarding suppression of evidence. It was from a combined map and Engle hearing. And I would note that this Appellate Division has requested the people's exhibits from that hearing, and we've learned now that they're not available. And as defense counsel,
well, if we're talking about the exhibits with respect to the dash cam.
Exactly.
Yeah, in the radio dispatch.
Exactly.
Yeah, we have those, and we've had the opportunity to listen to them and watch them. Yep.
Okay. Thank you. Then I'm going to focus on the consent argument, Your Honor. 2 points here. One is that the defendant did not consent to the search of the vehicle. And two is even if the court...
He uses the phrase in response to the question of consent to the search, at least as I picked up and listening to it, words to the extent that it's not a problem in response to the consent, and also I'm good. And the officer, why is the officer not fairly interpreting that to provide consent?
Well, because...
Admittedly, there was country western music being played over the radio, which I cannot for the life of me understand why that was happening, and it made it difficult to hear, but with some concentration, you certainly heard the defendant say those words.
Well, here's the issue, Judge, and it's from the Court of Appeals, People versus Whitehurst. They made it very clear that the people have a heavy burden through clear and positive evidence that there's a consent to allow a warrantless search. So the bar is very high to make sure that it's clear and positive. It can't be ambiguous. The office...
Feel I'm good?
Pardon?
I don't have a problem, I'm good, isn't clear?
That's the quotation, I believe, was, I'm good, when he was asked, which I have no idea what that means when someone asks to search.
Well, the language I heard was, it's not a problem, I'm good. And would it be fair for us also to consider as part of the consent deliberation here that once the officer then proceeded to go look in the car, in the trunk, the defendant wasn't objecting and saying, I said no, don't do that. I didn't give you consent. There was no reaction at all to that. It was...
Let's be clear, though, Your Honor. You're saying there was no reaction from the defendant at that point. Prior to that, on a routine traffic stop, the police officer draws his weapon on the defendant. He calls for backup. Additional officers arrive. Now a second police officer draws his weapon. They remove the defendant from the vehicle. They pat him down. They search him. They find no weapons. They detain him inside the rear seat of a police cruiser. They start interjecting a conversation about a robbery They ask him if he
Now,
is.
we're familiar, we understand the facts, and I'll grant you this, but I'll grant you this, counsel. And the officer, I think, was asked at one point about this, and he said, yeah, it's not normal to draw your weapon for a routine traffic stop, a running of a red light. You know, the officer wouldn't normally pull his weapon, but the radio dispatch indicated 20 minutes before there'd been a robbery. Was that an unreasonable approach to draw the weapon and shield it behind him as he approached the vehicle?
Regardless of whether it was normal procedure for the police, those circumstances created a situation of duress for the motorist.
You're saying that that's why the defendant wasn't going to do anything to stop them from doing continuing their search.
He is capitulating to police authority, which is exactly what we want our citizens to do. I couldn't imagine being so bold under those circumstances that after the officer leaves, that you're then going to, he's locked in the back seat. So my argument is that even if those words could be construed as consent, they were given under duress because of he's capitulating to police authority. But I would challenge whether or not that rises to the level that the people require. I would just note for the court is that on direct examination, the sworn testimony of the officer when he asked for consent was, quote, this is coming from the defendant, quote, yes, you can, I'm clean, end quote. That's what the officer testified that he heard. So then it's only when he was confronted with the videotape where the words are, I'm good, it's not a problem, come out, which I would argue on its face is ambiguous as to what that means. So I have no idea if the officer's actual recollection, if you take the officer at his word, he heard the words, yes, you can, I'm clean. Those were not the words that were uttered.
Mr. Hajdu, excuse me.
Yes.
You're talking a lot about the consent issue. What
Yes.
I want to do is back up just for a second. Tell me where the first matter of law violation happened. Is it the stop? Is it the invasive questioning? Or do we get all the way to consent? I mean, at what level do we have to seize the moment, so to speak, on your argument and say, here's the violation as a matter of law,
Well,
as opposed to credibility determinations? Thank you.
it's just as you've outlined, it's stepping stones, Your Honor. It's first that there's a three-prong approach that I outlined in my brief, but effectively under Engel, you have to have a basis for the stop.
That's a credibility determination, right? Sorry.
That is
Okay.
credibility.
So it's not a matter of law, so to speak. When does it become a clear matter of law that favors you in the step analysis without a credibility determination?
When you get to what the officer observed at the scene, that he considered the basis to then raise his questioning to the point where he's asking whether or not there's weapons. That's a Garcia case.
Right, you're at the invasive question.
Absolutely.
Got it.
And
Thank you.
I just would, if I could highlight for the court that the first report is two males, black hoodies, bandanas, black pants, no description of age, skin color, ethnicity, no description of a vehicle. The only thing that was a match for that vehicle is that they had two men inside, and then after it was pulled over, you could see that their pants were dark. It wasn't, the second report didn't come out until later, after it had already escalated to the point where he's talking about a robbery, asking about guns and weapons. So at that point, I believe the Appellate Division can jump into the analysis. Last point, Your Honor. The people argued somehow that the defendant abandoned the issue of consent. And I just want to be very clear. The defendant filed an omnibus motion. He argues the evidence was seized without consent. That's at page 405 of the record. At the hearing, defense counsel specifically plays the audio that you listened to that refuted the officer's testimony about consent. And then the defense counsel submits papers. This is at page 445 of the record, arguing, quote, "The people have not met their burden to prove that the consent provided for the warrantless search of the defendant's vehicle was properly obtained," end quote. So there's no abandonment of that issue. And under the case of People v. Whitehurst, it's a heavy burden on the people. They're the ones required to show positive proof. We don't have to prove anything.
Thank you, counsel.